weeks ago, we raised the importance of supportive relationships for youth in care. And so school disruptions can impact the youth's ability to maintain connections with supportive administrators, adults, teachers, guidance counselors, and those type of folks. And so we know that supportive relationships and a positive, stable educational experience can improve and promote a youth's healthy development and overall well-being, which is the purpose of ESSA. So ESSA's protections include remaining in the same school unless it is not in the child's best interest. We'll discuss a little bit more about best interest factors in a little bit. Immediate enrollment in school and transfer of school records. Ensure school transportation, which we understand is a really big issue for youth being able to ensure school stability. And it requires that every state education agency, known as SEA, to have a point of contact for child welfare agencies. And local education agencies have to have a point of contact if a child welfare agency has indicated that they also have a point of contact. The point of contact basically is a liaison for the youth or the student when they're in school. Just keep in mind that the child welfare agency is not required to under ESSA, but can designate a point of contact. So specifically for students with disabilities and unique needs, child welfare agencies are required to do the following. They must work with children and youth with disabilities to meet the requirements of an existing IEP. They have to notify institutional placements of a student's eligibility for special education services and when the student should be returning to the local public school. And they have to provide information about the educational needs of the youth. So in that sense, all the protections that youth have under such, all the protections that youth with disabilities have under other federal laws, they apply to child welfare agencies as well. So, remaining in school, in the same school when it's in the child's best interest. What we call school of origin is an educational setting that the student attended before or at the time they initially entered care and before any placement change. So if it's in the best interest for the youth to remain in their school of origin, that should occur. So students who are in foster care must be permitted to enroll or remain in their school of origin unless it is against their best interest. And this protection also applies to youth who are transitioning or transferring, to residential placements. Best interest factors that advocates should keep in mind but are not limited to the child or youth preference for school, the availability and quality of services to meet their needs, and the impact of a school transfer, including commute. Making a best interest determination should be a collaborative process between the child and youth school and the child welfare agency, and each state may design and implement a best interest policy to ensure school stability for its students. Keep in mind that as an advocate, you can or should be involved at the best interest determination stage. So going back to what Lisa mentioned about the review hearings that child welfare agencies hold, that may be a point where a best interest determination is being made, and we encourage you to find out when those meetings are being held and get involved as much as possible. So under ESSA, immediate enrollment in school and transfer of school records must occur. So what that means is prior to ESSA, there were usually delays or just completely missing records for students. And under ESSA, that changes. So if a best interest determination has been made that a student should attend a new school, that student has to be enrolled immediately. Even if the student doesn't have all the required enrollment documents and school records, the student should still be enrolled in the school. Youth are entitled to enroll in the local public school where their placement is located. And enrolling schools must immediately contact the school last attended by the student to obtain relevant education records. So, enrolling schools is defined as the school that the student will attend, and the child welfare caseworker may also have a child's education records, and they are authorized to obtain such records under FERPA. This is to ensure that records and information that the child needs to continue their education and to promote school stability are in place. So, school transportation. As we all know, transportation is a huge factor in whether a youth will have stability in school. And so to ensure school stability, transportation plans must be created to determine which agency will be responsible for arranging and funding transportation for students. Under the IDEA, transportation is a related service that must be provided to a student if the IEP team determines such a need. So many states are currently working on finalizing their transportation plans to determine who will cover additional costs for the student's transportation. ESSA provides that transportation should be cost-effective, that local educational agencies may spend an amount equal to but not more than 5% of their funding to pay for transportation for students who transfer schools. And where additional costs arise, there are 3 payment options that child welfare agencies and educational agencies may choose to employ. Those options are the local child welfare agency agrees to reimburse the local educational agency agrees to pay for the cost, or the 2 agencies agree to share the cost. Transportation is guaranteed by the law under both ESSA and the IDEA. So if you're working with youth who have experienced delays due to transportation, reach out to the youth caseworkers, the local education agency or state agency, as well as the attorney for the child. So point of contact. All state educational agencies are required to designate a point of contact for child welfare agencies under ESSA. Local education agencies only have to designate a point of contact for a child once the child welfare agency notifies the agency that it has a point of contact. So again, going back, the child welfare agency can choose to have a point of contact for a youth in care. If they choose not to, that is not a violation of ESSA. It is optional for the child welfare agency, but it is good practice for the local educational agency to have a point of contact available for the youth. Point of contacts are responsible for, but they're not limited to, the following: coordinating with child welfare agencies to ensure that students in care are enrolled and regularly attending school, facilitating the transfer of a student's records, and assisting with the development of the best interest determination process and local transportation plans. So state plans were due initially on April 3rd to the federal government, but not all states have submitted their ESSA plans. The final due date for full ESSA state plan submissions is September 18th, 2017, and the state plan must include provisions about youth with disabilities, and protection and advocate agencies or teams should be involved in that process. The states that have submitted plans to the date include Connecticut, Delaware, Washington, D.C., Illinois, Massachusetts, Maine, Nevada, New Jersey, New Mexico, Tennessee, and Vermont. However, keep in mind that even for the states that have submitted plans, there is no guarantee that the plans clearly indicate how things will work in reality. As an advocate, you should learn what is in place in your jurisdiction by contacting your state or county Department of Education and Child Welfare Agency. So what can you do? You can find out the contents of your state plan and play a role in its development. You can find out who the point of contact is for your state education agency and get to know them. Learn if they are a point of contact at the local education agency and at your child welfare agency. You can play a role in the best interest determination, and you can notify both child welfare and education when transportation to ensure school stability is not provided or isn't being provided promptly. Most plans are available through a Google search. Otherwise, again, feel free to contact your state's education agency or child welfare agency to determine the best way to obtain the ESSA plans for the state. And so these are a few resources available to help you understand ESSA a little bit better, especially for the youth that you work with. The first is the Advocacy Institute's webinar series on how ESSA specifically impacts students with disabilities who are in care. The Legal Center for Foster Care and Education, which is a joint effort by the Juvenile Law Center, the Education Law Center of Pennsylvania, and the American Bar Association Center for Children in the Law, provides information about ESSA on a federal level and also possesses a number of toolkits to help states implement ESSA. So again, we encourage you to get involved in the planning process, and you can use some of those tools to help implement ESSA. And finally, the Leadership Conference Education Fund published a comprehensive guide about ESSA for advocates to use in promoting educational equity and school stability for youth. And so we're turning our attention next to school stability and meeting needs in the community. And so some of these are common issues that arise in the child welfare context. Once we go through the school stability and meeting needs in the community, I'll turn it back over to Lisa to discuss supporting the IEP process. So we're going to do a quick poll right now. What barriers to educational success do you see for youth in congregate care? And the options are lower quality education, uncredited coursework, credit transfer problems, no or limited access to life skills development, and isolation from the community. So take a few moments to respond to the poll and we'll be right back. So as you can see from the results of the poll, it seems like 100% of you responded that the uncredited coursework and credit transfer problems were amongst the biggest barriers for educational success. Isolation from the community came in second, unfortunately. And it seemed to be a tie between lower quality education and limited access to life skills development. And so challenges to maintaining school stability include the overuse of congregate care for youth in the child welfare system, which goes to the point that most of you selected, which is isolation from the community, congregate care settings with on-ground schools, using on-ground schools to address truancy issues and obstacles to putting appropriate services in place in the community. All of those go to the previous poll selections of no limited access to life skills, uncredited coursework, credit transfer problems, and low quality education. And as I noted earlier, ESSA is supposed to ensure school stability, and so one of those issues would be addressing the credit transfers. So even in states that have not implemented ESSA, the Fostering Connection Act makes the Child Welfare Agency responsible for developing a school stability plan for each child and for providing assurances that the agency has coordinated with the appropriate local education agencies to ensure that the child remains in the same school in which the child is enrolled in at the time of the placement. Or if remaining in such a school is not in that child's best interest, to provide immediate and appropriate enrollment in the new school, with all the education records of the child provided to the school. And this is a federal law. So Fostering Connections directs that in making decisions about a child's placement, the Child Welfare Agency must take into account the appropriateness of the child's current educational setting. And for a child who is or may be eligible for special education, that means exploring what kind of help the child needs, what services the child is receiving, whether that's general or special education, the programs and services in the IEP, are they appropriate, how the child is progressing, and whether services in the IEP are being delivered to the child in the least restrictive environment to the maximum extent appropriate for the needs of the child. So in maintaining school stability, federal child welfare law requires that youth be placed in the least restrictive, most family-like placement. If you attended our webinar last week, you know that provisions of normalcy encourage and require that youth in care are allowed to attend or participate in age and developmentally appropriate activities. There are the legal requirements under ESSA, which include that child welfare agencies must ensure school stability and that educational decisions should be made separately from placement decisions. So, you all should be familiar with some of these opportunities or supports available for youth with disabilities, which include transition supports, which is transportation practices, one-on-one aids, counseling, peer interaction training, consultations for classroom staff, functional behavior assessments, positive behavioral support plans, communications protocols, complete information for school records, coordinated services, appropriate mental health services, empowered educational decision maker, and 504 plan.
And just to back up for 1 minute, I'm going to go back to this last slide. These are supports that you guys are the experts in education planning, but these are not necessarily supports that child welfare team members are familiar with. So in terms of maintaining school stability, they might not know what resources they can access. This is a really great point of advocacy, just educating the child welfare team on what is out there and what can help them meet the goals that should be in place for a child is a really powerful tool and a great service that you could bring to the table for a youth that you're advocating for.
So we're going to go through a case example, and this is another interactive exercise, sort of like the poll. We're going to discuss Mimi, and we're going to ask you a question at the end, and you get your feedback. But as you can see on the screen, Mimi is an autistic 16-year-old. She's been placed in the child welfare system and living with a resource family in Friendly School District, excuse me. She's been attending the local high school for 2 years, and she has an IEP. She's currently on the basketball team and has a close relationship with her coach. But despite her success at school, Mimi's behaviors at home disrupt her living placement. So she's been placed in a congregate care setting 45 minutes away from her current high school. The placement has an on-ground school where staff have experience educating youth on the autism spectrum. So, focusing on school stability, what recommendations would you have for Mimi's education plan, and how can you help achieve them? You can take a few minutes and respond on the chat or the questions box.
Just a couple points to think about, and you can respond in either the question or chat box, whichever you have access to. Where do you think Mimi should be attending school? Or before you make that decision, what questions do you have? And then trying to think about some of the law that Natani covered in talking about ESSA, what legal supports are on your side for making that argument. Who might you talk to get some more information, or who might you talk to as part of your advocacy team to put that education plan in place?
Okay, so we've gotten a few really good responses. The first is that you would recommend behavioral support programming to be utilized in the home, continue education at Friendly due to no disruption at the school, which is a really good point and one we were going to point out. Another response is that you'd advocate at the very least for her to continue eligibility for the sports and extracurricular activities at school, and the length of the commute would be a concern, which is, again, another point that we were going to make. But if she's successful in a less restrictive school environment academically, you'd push pretty hard for her to continue at Friendly. And those were really good responses, and again, some that we were going to make ourselves. So again, some issues to consider specifically for Mimi include her credits, potential disengagement, which goes back to the point about normalcy and having supportive individuals in her life, special education, alternative education, behavioral problems, and permanency. And so the legal hook here would be that the case plan has to include insurances that the County Children and Youth Agency coordinates with the local education agency to ensure that Mimi remains in the school which she was enrolled in at the time of her placement. And so unless remaining in the school is not in her best interest, she should be in the school. And school placement changes need to be included in the IEP and agreed to by the education decision maker. And so some things or some points to consider when making the best interest determination include Mimi's preference, safety concerns, appropriateness, including any special education services, the commute, which again, we pointed out, a few of you made mention of, the expected length of placement, timing, if she had siblings at all, where those siblings would be placed. Again, pointing out the sports and extracurricular activities. Mimi's participation on the basketball team seems to be a really good opportunity for her because she has a close relationship with her coach. And then assessing the quality of the on-ground school. Placement should not dictate the school setting. And so the focus should be on, one, whether there's any evidence of a behavior concern at Friendly, and there doesn't seem to be, given the case example. Would going to this new on-ground school disrupt Mimi's ability to graduate on time? And if transportation is 45 minutes away, what does that mean for Mimi and her ability to concentrate once she gets into school? And does the on-ground school offer programming that's appropriate for Mimi? So those are all things that you should consider when advocating for her. And the other thing is, who's going to issue Mimi's diploma? She's 16. She's only a few years away from graduation. So those are the things that everyone should keep in mind as they're going into the best interest determination process for a youth.
Before I move on, just 2 points to make here when we're talking about youth who are in the child welfare system. One really important fact in this case is that Mimi has a close relationship with her basketball coach. And as we talked about in our last webinar, and for those of you who weren't able to attend, we know that having close relationships with supportive adults is crucial for youth who are in care. That a close relationship with an adult is one of the most predictive factors of success in adulthood for youth who are in care. So maintaining that relationship is really important, and cutting it off by sending her to a new school might be highly detrimental for Mimi. And it's something that can be addressed in terms of school placement, but also something that can be discussed in her child welfare transition plan, which we'll be talking about shortly. But if she doesn't have that relationship, who else does she have a relationship with? We should know the answers to that question for youth who's in the child welfare system, but it's something to think about. And point number 2 relates that somebody raised about putting a behavioral plan in place at the home, because that not only could potentially address the need for school stability, but could also keep Mimi in a home that is family-like rather than sending her to congregate care. So these issues can frequently be intertwined, even though a placement decision should not be dictating, a child welfare living placement decision should not be dictating school placement. They are tied up closely. So being able to address both concerns with one service is really helpful and really powerful.
And so a few advocacy tips. Use special education, 504 plans, and community services to support youth in the least restrictive educational and placement settings. Use your investigatory authority to understand high rates of on-ground school or congregate care school settings at particular placements. Challenge agency contracts with providers that require the use of on-ground schools. advocate for addressing underlying causes of truancy. And so for this particular point, I know we haven't gone into truancy too much in this presentation, but oftentimes we find that youth are being sent to congregate care settings to address truancy, when in reality the child welfare agency caseworker could address the underlying issues of truancy, whether that's transportation to school, clothing, food, those type of issues can be addressed by working with the caseworker. So that's something to keep in mind. And address the child's educational needs before the youth is placed in an on-ground school, or if in your jurisdiction it's known as something else, but a congregate care school setting. So we just want to ensure that, those are the advocacy tips that you have when working with youth who are in the child welfare system to ensure that their educational stability needs are being met.
So we're going to move on to talk about the IEP planning process and how the child welfare system and PNAs can work together to come up with a more robust, more supportive IEP plan and child welfare transition plan for youth with disabilities. Now we recognize that IEP planning, you guys are the experts, so our goal here is to help you see places where you can kind of harness that expertise and support youth who are in care, and also to talk about some of the overlaps. There is a parallel transition planning process in the child welfare system, so how the two systems can work together to better serve youth. Now for youth who are in care, there are specific challenges that are amplified when it comes to developing an appropriate IEP. And the first is over, under, and misidentification of educational needs. Youth in care are frequently over-labeled or under-labeled or mislabeled. Part of that is the next problem, lack of information or records. Part of that is due to a separate problem, which is no real advocate in place for youth, or at least a consistent advocate in place for youth, and just the child welfare system not generally focusing on educational needs. Another issue is uncoordinated services, and that's going to be something that we're talking about today. And we mean services in the education system, but also services outside of the education system. So those that they're getting in their homes that are court orders or otherwise being provided to support them. We covered the inappropriate or unidentified educational decision maker, and we'll be talking about educational decision makers a little bit later on. And also improper mental health services that can lead to mental health disruptions. So for instance, school disciplinary measures that are being used in place of behavior supports that could be positive. Now when a youth is in the child welfare system, that does not change the obligation of the LEA or the IEP team to create and implement a plan. It does, however, create a potential new person who can be invited to an IEP meeting on the child welfare team. A caseworker might be an appropriate person to invite to an IEP meeting as a person with special knowledge or expertise. From our perspective, it's generally a good idea to include them because they have a lot of information about what's happening in the child's life on a day-to-day basis. When youth are in care, the LEA has a specific child find obligation that applies to all youth, but it does apply specifically to youth in care. So the LEA should be making a special effort to determine if youth in care are entitled to special education. And a final point, keep bringing up educational decision makers, but child's caseworker cannot be the child's educational decision maker. We'll be talking about who an appropriate person is, but if the caseworker is saying that they are that person, that they're serving as the IDEA parent, that is not correct and somebody else has to be identified. So, the educational decision maker. We know that the IDEA relies heavily on the youth having an advocate in the room that for many youth is the parent, somebody who is familiar with their history, knows what services and supports have worked for them in the past, and is really making sure the process is going forward as expected. Unfortunately for youth in care, there's not always that person. As we talked about at the outset, they may not have a legal parent. They may have a parent who is uninvolved for a number of reasons, or a parent who just isn't familiar with what's been happening to them, even if they want to be involved in the future. But without that advocate, we know that IEP planning doesn't go as well and outcomes aren't as great if there's no strong advocate in the room. So the IDEA, of course, thought of this and came up with provisions. To identify an alternate if it can't be the parent. And also juvenile courts, so the courts that are overseeing the child welfare case, have the authority to identify somebody to act as the IDEA parent if there isn't a legal parent in place to make those decisions. And the IDEA recognizes as a parent who the juvenile court can appoint as a legal guardian or other guardian with authority to make education decisions. Another person in a parental role with whom the child lives, so that could be a grandparent or another relative. And that's it. But generally, if the biological or adoptive parent, what I've been calling the legal parent, is attempting to act as a parent, they're presumed to be the parent under the IDEA. Now, if there is no IDEA parent, the court can appoint a surrogate. And the surrogate is really if there is no parent under the IDEA. And these are all points to advocate for in court. If you don't know who's making decisions on behalf of a child, then it's important to raise it with the child advocate or another person who's a party to the child welfare case to ask the court to appoint somebody. And once that person is appointed, they can serve as a powerful ally to you and be a point of contact for you to talk about the educational needs of the child and to really coordinate child welfare and IDEA services. So we're going to talk about who needs a surrogate parent. We're going to go through 3 case examples that are very quick, and we're going to ask you to vote on who you think would need a surrogate parent. The first is Casey. After a visit from a child welfare worker, Casey's parents voluntarily agreed for Casey to live temporarily with his aunt and uncle while a safety plan is put in place. This is temporary removal. Simone. She's placed in kinship care with her grandparents while her mother receives inpatient mental health treatment. Simone's mother does not respond to requests to authorize an initial evaluation for special education services. And Angela. Angela's parents' rights have been terminated and she lives in a group home. So we are going to ask you to vote which, if any, of these youth do you think are having slight technical difficulties? There we go. Which, if any, of these youth All right, we got that fixed. Which, if any, of these youth needs a surrogate parent? Thanks for bearing with us there. And you can vote for 1, 2, or 3. So we're going to launch the results. So let's talk about Casey. So Casey is voluntarily living. His parents have agreed for him to live temporarily with other family. He does not need a surrogate parent. His parents' rights are still in place, and as long as they are continue to be involved, they are presumed to be his parents for purposes of the IDEA and can continue to make decisions on his behalf. Simone is actually in a very similar situation. The one glitch is that her mother is not responding to requests. So at this stage, it's a little unclear. And part of this question is a trick question about terminology. If she's in kinship care, she can have, and her mother is unable or unwilling to make decisions, then her grandparents could be the educational decision maker. So, and they would be doing that as a parent under the IDEA. And it's just not called a surrogate parent because they are recognized as a parent under the IDEA. But Angela does need a surrogate parent. She has nobody in her life to make decisions for her. She's in a group home, so she's not in a family-like setting. There's nobody like a parent there to make decisions on her behalf. So she does need a surrogate parent if one is not in place. This is just
We just want to double check and make sure that you're seeing the screen that we have on. Give us one moment.
Okay. Another brief technical glitch. Thanks for bearing with us again. But just a resource to highlight, this is the Legal Center for Foster Care and Education that Natani mentioned before, which is a collaboration between Juvenile Law Center, Education Law Center, and the ABA Center on Children and the Law. Has some resources on educational decision making, including resources, fact sheets, and some state law specific questions on the educational decision maker. So we'd encourage you to check that out if you have questions. Now, the whole point of appointing an educational decision maker is to make decisions on behalf of the youth who's entitled or may be entitled to special education services. And just to back up for a second, when I've been talking about educational decision makers, I have been talking about educational decision makers under the IDEA. It is possible that youth that you're seeing are not entitled to special education services, but they still need somebody to make educational decisions on their behalf. And again, this is something that a juvenile court can deal with. Not under the IDEA, but courts have broad dispositional authority, and they are empowered to appoint somebody to make decisions on behalf of youth when it's needed. So backing up, the whole point of appointing an educational decision maker is to be involved in the transition planning process. And we wanted to highlight the transition planning process under the IDEA and the transition planning process under the Fostering Connections Act, which dictates what supports the child welfare system needs to address when helping plan for a youth future. And it's really important that these two planning processes be done concurrently so that the goals and the strategies for achieving them don't conflict, so that youth can take advantage of what are complementary services in both systems. But unfortunately, we know that this isn't happening. Youth in care generally have poor transition plans in their IEPs. We know that these systems aren't working together. So this is a really important place for you to come in and raise with the child welfare team kind of what else is going on. And PNAs can be a powerful liaison between the two processes. And again, an educator and advocate for ensuring appropriate services. I'm not going to read through these, but what's important is that both planning processes have to involve the child. Under Fostering Connections, it starts at 14. Transition planning can start at 14, but the deadline is that a plan has to be in place at least 90 days prior to exiting care. So you shouldn't be exiting care without a transition plan in place. And also some of the services. The services are a little bit different. Housing, insurance, education. So again, a very natural place for overlap in getting the two teams to talk. Local opportunities for mentors and continuing support services. So the services and people that are going to help you transition to adulthood. And workforce support and employment services. And this can be interpreted broadly and can include things like post-secondary education that will help you be prepared for the workforce. I also want to highlight independent living skills that are supposed to be addressed under the IDEA transition planning. And these are really critical for youth who are in care. For those of you who are on our call on the webinar 2 weeks ago, you know that the child welfare law provides for normalcy. And one of the reasons that normalcy or just participating in age and developmentally appropriate activities is so important for youth in care is that they need to develop these independent living skills and historically have not had the opportunity to just be involved in extracurricular activities, hang out with their friends, act independently and explore their own interests. And despite normalcy, we know this is still true for youth who are in care. So working on those independent living skills through the IDEA transition planning process is really important for youth who are in care.
And we also want to point out that under the IDEA, transition planning for youth, that begins at the age of 16 at the latest, just as a point of note between both.
Yeah, so there is a substantial overlap for while kids are, for the transition planning processes for both, under both laws. So setting goals. Under both, the main point that I want to get across here is that under both the IDEA and child welfare transition planning processes, goals need to be individualized to the student. We know under the IEP planning process that there should be assessments, and that those assessments help articulate specific post-secondary goals in specific areas. And those assessments and those records that you use in the IEP planning process can also be really critical in the child welfare planning process. So making those assessments and those determinations and those specific articulated goals available to the child welfare team can be really important.
And so just for consideration, post-secondary goals can be attending college, going to a vocational training program, and getting involved in career and technical education programs as well. So as an advocate, it's ensuring that the youth's goals or their interests are being brought up with the child welfare system as well as the educational system.
We also want to highlight this IEP transition planning toolkit for advocates. It's something that we have used with child welfare teams to help them understand the IEP transition planning process and to help them think about IEP goals and how the two systems, how the child welfare and IDEA teams can work together to advocate for youth. And this is something that you as advocates who are working with child welfare professionals can use to help them understand the process as well. This is a toolkit that is universal, that can be used by anyone. It has instructions in it. It is a complete toolkit. So it can be used to help others who are involved in the IEP transition planning make the most of the process. So we'll include that in an email to you at the end of the presentation, but it's just something for you to kind of help get other people involved. And also just another highlight that talks about how the IDEA and fostering connections overlap. And it's a good resource for talking about education planning for youth who are in the child welfare system who are entitled to child welfare services. So to sum up, some tips for the child welfare, for the IDEA transition planning process, coordinating the two plans is really, at its most basic, what we're talking about doing here. And part of that is getting the right people in the room for transition planning. So in education transition planning, that might mean the caseworker, it might mean foster parents, it might mean a child advocate. But anyone in the child welfare system who has special knowledge or expertise about the child might be an appropriate person to be in the room. And at the same time, it might be appropriate for people involved in education planning to be involved in case planning meetings in the child welfare system. Getting information to the child welfare team is also a really great resource that you can provide as advocates who are familiar with the children that you're working with. Conducting assessments before setting goals, so that overlap between the assessments that you're getting on in the IDEA transition planning process and getting them over to the child welfare team. identifying, engaging, and empowering an educational decision maker can make a big difference for having somebody be an advocate on behalf of the youth in the education transition planning process. And then educating and empowering the youth himself. That's important both for the transition planning process and also in terms of youth who age out of the child welfare system or once they are independent adults, having those skills. So working on that as an independent living skill, as well as addressing their needs while they're still involved in the child welfare system. And finally, working with the child's attorney to advocate in court for required services and support. So when all else fails, you think this youth needs something that he or she isn't getting, the judge can be your friend if you can get in front of the judge. So we're going to end with addressing post-secondary challenges and opportunities. We're mostly going to be talking about college, but a little bit at the end about vocational rehabilitation. And the reason we talk about post-secondary education is that it's frequently not an option for youth who are in care, or it's not seen as an option. It's not something presented to them, but we know that youth in care have much lower levels of educational attainment than their peers who are not in care. And PNAs in the child welfare system, and the child welfare system especially, should feel an obligation to hopefully improve the college attendance and graduation rates for youth in care. So our third and final poll of the day that we're going to ask you to respond to: what is the biggest challenge you have seen to youth in care obtaining post-secondary education? Let us know what you think. Obtaining post-secondary degree not given as an option to youth in care, lack of family and other support in choosing appropriate post-secondary settings and providing support along the way, inability to pay for school or support oneself while attending school, or youth may lose support of the child welfare system at age 18. So interestingly, everyone said losing the support of the child welfare system at age 18 is the biggest challenge. And we will be addressing this a little bit when we'll be talking about extended foster care. But that's really interesting from my perspective, because I see it, and not working with youth directly, as kind of a shortcoming in planning. So that's really interesting, and it's kind of enlightening for what planning needs to address. And it is that aging out, that time when youth are most vulnerable. So thanks everyone for that feedback. I feel like I don't have a lot to say. Now I could just ramble, but I'll refrain. So extended foster care. And extended foster care, when we say extended foster care, we mean really the care for youth that extends beyond age 18. So we say foster care, but it doesn't necessarily mean that youth are living in foster homes, but it means that youth are still getting case management and services from the child welfare agency, and they're getting court oversight. And importantly, pursuing secondary or post-secondary education can mean eligibility for extended care until age 21. And this is state-specific. Not every state offers extended foster care, and the rules for eligibility are different. And in some states, extended care can go beyond age 21. But for the most part, in states that offer extended care, going to college or continuing high school can mean that you remain in care until age 21. So in considering what options youth are going to pursue after high school, the benefit of extended foster care is something that should be on the table. The benefit of post-secondary education is something that all youth should be kind of given, because it just means additional support for them as they're older. So a couple things to think about is that when talking about post-secondary education and what it means for extended foster care, number one, what are the youth's goals for the future? What career path does he or she intend to pursue, and how can post-secondary education further those goals? What housing options are available to the youth, and this can be greatly expanded in states where youth have extended foster care available to them. For older youth, housing is can be a little bit more non-traditional, and many state plans will say specifically that living in a dorm is an independent living placement where youth can live and still be eligible for extended foster care. Also, the full-time versus part-time decision. States have different rules for how frequently you have to be attending classes, and it might mean that you have to attend full-time if they want to take advantage of extended care. It's also important to note that extended foster care is available to youth who are not in school. It's also available to youth who are working a certain number of hours a week, youth who are working to remove barriers to employment, youth who are pursuing other vocational services, and youth who, because of a medical condition, which can include a variety of disabilities, cannot pursue those other educational or employment options. And extended foster care can provide some really important benefits. In addition to the case management and independence and services that the agency provides, some specific supports they can provide is a place to live while attending college or training, financial assistance to meet basic needs. So we've heard a lot from youth. We have an extended foster care project here, and we've heard a lot from youth that even if they identify a school and a way to pay for it, they can't pay for books. Books are really expensive. So that's simply paying for books is something that a child welfare agency can do for youth who need it. We've also heard that youth need support in identifying appropriate programs, and that's something that agencies can provide in their case management services. We'll be talking about actually paying for education a little bit later on in the supports that are available. That's not generally something that an agency will do when it offers extended foster care, but there are other resources available, so we'll get to that shortly. And finally, youth may be able to re-enter care if they return to school. So, and that's secondary or post-secondary. And again, we've heard that youth frequently lack support when they're trying to re-enroll. So that can be a barrier to educational attainment, and it can also be a barrier to accessing the services that would be available to them if they were in the child welfare system. Some state laws will require that an agency help youth if they're trying to become eligible for care, but in other states there may be no support until they've already re-enrolled and the court determines they're eligible for extended care. So those are just points to keep in mind if you do talk to a youth who's trying to re-enroll, who's trying to get back into extended foster care. It's also something to keep in mind when we're talking about transition planning generally. Even a youth who doesn't want to stay in extended foster care or doesn't want to pursue post-secondary education, a plan B is always a good thing to have in place. And that is one of the reasons why. So, paying for school. The Chaffee program can be a really powerful resource for helping youth, former and current foster youth, pay for school. And it provides a number of supports in addition to education opportunities. It helps with employment, financial management, housing, emotional support, and assuring connections to supportive adults. And the Chaffee program its supports are available to youth who are still in care, and child welfare agencies have an obligation to identify youth who are likely to remain in care until age 18. But Chaffee programs are also available to youth who leave care after age 16. So even youth who have been adopted, have kinship guardianship, or some other who have achieved some other type of permanency are likely entitled to support from the Chaffee program. And finally, youth who have aged out of the foster care system. So youth who at age 18 or 21 have not achieved permanency are entitled to continued support in early adulthood. And for our purposes, the Chaffee program is really great because it provides educational and training vouchers to current and former foster youth. This is up to $5,000 per year. Youth must apply for the first time between ages 17 and 21, but they can continue to reapply until age 23. So it can be, it's not going to pay for all of college, but can be a very significant support to youth as they pursue post-secondary education. And assistance can vary by state. So there may be other requirements like personal assets are worth less than a certain amount. You might already need to be accepted to a school in order to apply. You must, while you're receiving the grant, some states require that you show progress toward a degree or certification. And then there are also in some states kind of some parallel programs. So there are state-specific scholarships available to youth who are or have been in foster care. Alabama has a program called the Fostering Hope Scholarship, which is available to youth who were in foster care when they earned a high school diploma or GED, as well as those adopted from Alabama foster care after age 14. So it's an even broader program than the Chaffee grant. And it covers tuition and fees for youth who are enrolled in a full-time or post-secondary certificate undergraduate degree program. And it helps eligible high school students begin planning towards their post-secondary goals. And the state program is available through age 26. So it's just one example of a state that's doing a little bit more for foster youth. And Alabama is not the only state. This National Post-Secondary Support map identifies different supports that are available state by state for youth who are or have been in foster care, as well as state tuition waivers, and it's a good resource for any youth who is thinking about pursuing post-secondary education. It's also a good idea to know your state independent living and educational training voucher coordinators, because they are experts on what services and supports are available to current and former foster youth. So this is a link here to a current state-by-state contact list of those people. It's actually updated as of today, so the information is good and can be a great resource for getting questions answered. The FAFSA can also be a great way to help youth pay for school, and foster youth who were in care at age 13 or older are considered independent on the FAFSA, and that is true even if they exited to permanency. So even if they were adopted after age 13 or entered a guardianship arrangement or left care for another reason, they're considered independent. That is great because when you can check independent on your FAFSA, it maximizes the support that's available to you, because only the youth's income is considered for eligibility. So adopted youth, adoptive parents would not count in determining eligibility. So some points of advocacy around exploring and paying for post-secondary opportunities. First, find out your state independent living or ETV coordinator. Address post-secondary education as part of the transition planning process. And as we talked about, that's important not just for coming up with how youth are going to pay for it, but as a large, just making sure that it's on the table, that it's something youth know is available to them, and to get them thinking about it early on, so that they do have a fair opportunity to pursue the future that they want. PNAs attending the child welfare transition planning meetings, so just being in the room to advocate for youth can be very helpful. And again, empowering youth to advocate for him or herself, so that once they are in a post-secondary setting, they have the skills that they need to be successful there. Help make sure that youth are aware of and apply for all the financial assistance that they're due. There is more out there that is available for youth who are in care, and obviously any little bit helps. Help youth take advantage of extended care and aftercare benefits. So even youth who aren't in extended care have services that are available to them after they leave care through the Chaffee program. And this final point, consider delaying graduation until age 21. It's a little bit separate. But we just wanted to make the point that once youth graduate from high school, they lose their entitlement to special education services under the IDEA. And there are supports that can be put in place under a 504 plan, but they're a little different, and they're certainly not as robust, and they're not entitlements. So it's just something to keep on the table and raise with the child welfare team as well, so that they're aware of what a youth is losing when they graduate from high school. And we also wanted to talk briefly about vocational rehabilitation. Again, you guys are really the experts in this area, but the services that are available to youth, again, are not something that the child welfare team is necessarily thinking about or is even aware of. So just like a lot of planning for post-secondary education can become a real possibility if somebody is in the room advocating for the youth, the same thing is true of accessing vocational rehabilitation services. So raising youth eligibility at educational planning and child welfare planning meetings, helping the child welfare team navigate the system. This is new to them, and even if it's not where their expertise lies. So having assistance can be helpful for the youth. And finally, including applying for services as part of the transition plan, identifying the services that are going to be in place for youth after he exits the child welfare system and how he's going to access them is an important part of the transition planning process, and vocational rehabilitation should be a part of that. And finally, asking, getting help if you're not making headway in the case planning process, advocating in court. So getting the child advocate, for instance, to request support for an application. So we are going to wrap up, and these are just some takeaways, some general points of advocacy of how PNAs can support youth and help youth obtain a quality education when they're in the child welfare system. And the first is to leverage the services and support. So under child welfare law, using the case planning process, which can include educational planning, using transition planning to identify supports for youth, and really harnessing the benefits that are available under the federal child welfare law to support higher education and training. Leveraging the ESSA provisions for foster youth around school stability, and leveraging the juvenile court's authority to order whatever services and supports meet the youth's best interests, and helping the child welfare team identify what those supports are. And of course, to do that, making connections with the child welfare team, and those can be systemic connections with the child welfare agency, or they can be more case specific. The caseworker for a given child, their attorney, their non-attorney advocate, so that you have a point of entry to all of the services and supports that are available in the child welfare system. And finally, bringing your expertise to the child welfare team. These are areas where special education 504 plans, vocational rehabilitation services, and other supports that can create an optimal education setting. These are not things that the child welfare team has a lot of expertise in, and so sharing your knowledge and helping navigate the system can be really helpful in an individual case.
So again, we want to thank you for joining us. We want to thank NDRN for hosting this webinar. And we just want to let you know of 2 upcoming webinars. The next is on Tuesday, June 13th. It's entitled Achieving the Least Restrictive Setting in the Child Welfare System, What Disability Rights Advocates Need to Know. And the following is Thursday, July 6th, which will be about navigating adult serving systems after the child welfare system. So that goes back a little bit to the point that for youth, once they exit care, there isn't any support. You can find some support through adult serving systems. And so we encourage you to attend both webinars. And again, we will send our PowerPoint to you, include the national fact sheet that has some information, as well as the Pennsylvania IEP Toolkit. Thank you so much for participating. If you have any questions, please feel free to let us know. You can reach us at the following. Thanks once again.